The servicing representatives, they become very familiar with all of these tasks too. It's becoming familiar with probably twice as much material as maybe they contemplated having to know, when they got into the space initially.
The Weekly Friedman, your source for the most essential information in the default industry, with your host, Adam Friedman.
When you think about a servicer's role in relation to a defaulted mortgage loan, typically you think about them hiring an attorney and assisting as that foreclosure action or eviction action moves along. In reality, a servicer could take on many more responsibilities and obligations in relation to that loan. These can range from property preservation towards certain elements involved with the deceased borrower's estate. To help us walk through some of these topics, we have Senior Appellate Counsel Stephen Vargas. All right, Steve, thanks for joining me today.
Oh, nice to be here. Nice to see you, Adam.
Always good to have you back. You're one of the more popular guests we have on this show.
Thank you.
I'm always worried you're going to go create a spinoff and just leave me.
A new topic today that you and I have not discussed.
When somebody thinks about what a servicer's doing in default, right? The obvious thought is foreclosure, moving an action forward.
Exactly.
And I mean, we both know firsthand that the issues they can confront can go well outside that court action.
Exactly. And typically, servicers are processing payments, and then, like you said, in the default context, trying to recover payments through the foreclosure of the property or through a loss mitigation option. But the topics we're going to talk about today span far beyond what you'd think, even going back to law school, thinking about mortgage enforcement, a topic that's taught more in law school now, into the practice areas that you didn't necessarily think you'd have to have knowledge about. But when you're involved in the practice space, you have to have extensive knowledge about both of what we're going to talk about today.
One thing I always tell people is that when you're a foreclosure attorney or when you're managing foreclosures, you really do have to know everything about real estate law.
Yeah, absolutely.
So when we think about property pres, right, and we think about a servicer getting involved in preserving the property, that could mean fixing a roof. It could also mean mowing the lawn. Is this for cosmetic reasons? Like, why is a servicer mowing the lawn?
As far as cosmetic, I think no, in a sense. It's to preserve the servicer's investors' interest in the security, to keep the property in as good condition as possible, to maximize the appeal for auction bidders. However, to your point, there are many legal requirements that require a servicer to go far beyond upkeeping the cosmetic aspects of the property. And it could be the trash on the curb. It could be the lawn being kept to a certain height. It could be repairing broken windows or doors, securing access. So like you're saying, it's not as simple as servicer in its own interest or in its investor's interest, exercising business judgment, trying to say, we want the property to be as appealing as possible for auction bidders. They have to keep it up with local and state requirements that if they don't keep up with those requirements could result in significant financial penalties.
And these penalties are against the borrower, the property, the servicer?
The state and the local municipalities typically will look to everyone. They will see that the borrower, as the owner of the property, we're talking about a situation where the borrower is the owner of the property, or a corporate entity, let's say in a BPL circumstance, is the owner of the property, and the servicer has a mortgage on the property that's in default. The liability would actually exist, depending on the municipality, depending on the jurisdiction, potentially in a worst case scenario for the servicing industry, for both. So the servicer would have an obligation and the borrower would have an obligation. And in the event the borrower or the corporate property owner fails to fulfill the obligation under the local or state law, the servicer has a concurrent responsibility to bring the property up to code, so to speak. Some penalties range from daily to periodic. They accrue interest. And when you think about how long that process can take to repair a property that's left in disrepair, you're talking about sizable potential penalties being assessed.
We've seen, we need to see the chief executive officer of this servicer come to court in a month if this is not cleaned up, right? I mean, that's an extreme example.
It shows worst case scenario, and it also shows the scope of the court's authority. In the proceeding you're referring to, the court is authorized to call in who they think is appropriate to resolve the situation. So sometimes it could range from even a vendor. It could be a property inspection vendor who believed the property was being maintained properly, or signed some paperwork or produced some paperwork to the servicer to try to show that the property was being maintained, get summoned to court to explain what the servicer did, whether it's an inspector or even the entity that actually was doing the repairs. And like you said, in a more concerning scenario, someone higher up illustrating the municipality or the state or the judge's urgency to get something resolved. There are some examples in, for example, New York, where the situation was so severe that neighbors were complaining. The mayor of a town was aware of a particular blight on a particular property. Articles were being published. And all of a sudden, then there's risk exposure, not only from the financial risk and the legal risk associated with violating a statute or a local ordinance, but then, like you said, then it's a bigger picture concern. Is it a reputational concern? And all of a sudden, could you be talking about high number penalties beyond simply a $100 fine for not putting out the garbage on the curb correctly?
Why would a servicer get involved in estate issues?
Typically, when no one from the estate steps up. I'll give you two examples. Before an action's commenced, the servicer on behalf of the investor or the investor has to take action. You can't bring an action, generally speaking, against the deceased party because there's no jurisdiction over that party and the action would be a nullity. So you have two options. Typically, you sue the heirs at law, distributees, devisees. In many instances, you don't know who the heirs are, which is a complication. But in the event you know who the heirs are, you could bring an action against the heirs. Some courts require before an action that you bring an action against an estate representative. And sometimes during the pendency of an action, and maybe that's really more common where you see this, is that a judge has discretion in a case to require an appointment of an estate representative if an owner dies during the pendency of an action. What happens is if no one from the estate, if none of the beneficiaries or devisees, distributees, step up to file a petition in a probate, a surrogate's court, or probate court, whatever the jurisdiction's court is referred to, the servicer as a creditor has the ability to file a petition for the appointment of a fiduciary, an estate representative, to defend the foreclosure action on behalf of the estate. It's a time-consuming process. It's a costly process. The servicer is responsible for advancing those costs to have an estate representative appointed, but there are certain circumstances where a servicer has to do that in order to have a proper party to sue. And in some instances, a court will not let a foreclosure continue in the absence of the appointment of an estate representative, despite the case law that exists that allows the foreclosure to be commenced against the heirs at law. So, like I said, there's two options. One would be to try to substitute in the heirs at law and not have an estate representative appointed. Sometimes a court will direct that a state representative be appointed rather than the heirs at law. So if the court chooses to go in that direction, it may be necessary, and again, jurisdiction specific, judge specific, judges have a lot of discretion to decide what's the best way to have a case proceed. It may be necessary for a servicer to actually be a petitioner in surrogate's court for the appointment of a representative to sue the appointed representative. And you don't get to choose the representative, obviously. The judge will choose the representative. But it's a situation that seems unconventional. You're saying we're going to pay the fees and spend the time filing a petition in a court to have essentially our adversary appointed. And the appointee can defend the case. It's not as if in every instance it would simply be an uncontested foreclosure. It could be a situation where you have somebody appointed and then they file a responsive pleading on behalf of the estate and you're actually litigating with the individual who's an attorney who you just had appointed.
It's a crazy situation. Both these responsibilities, preserving the property and then dealing with estate issues, they are kind of outside the scope of what someone
exactly.
would think.
Default servicing attorneys, and to the second point first, would have to become experienced in the surrogate's court because there's many instances where the surrogate's court practice is going to be necessary. And then also, like you mentioned, very strong familiarity with these local codes, statewide codes, the ordinances, to know about the property preservation aspects and to have familiarity with that as well, because if you're not acutely familiar with the property preservation situation, there's going to be risk associated with the law firms trying to represent the clients in connection with property maintenance, as well as having appointees made.
It's very interesting. I think it provides a very good full scope of what our clients are required to do.
A really interesting practice area, far beyond just regular mortgage default, like you mentioned. And servicing representatives, they become very familiar with all of these tasks too. It's becoming familiar with probably twice as much material as maybe they contemplated having to know, when they got into the space initially.
Well, Steve, thank you for joining me. Informative as always.
Yeah, thanks for having me again.
Thank you for joining Steve Vargas and I and the Weekly Friedman, your source for the most essential information in the default industry. Thanks for tuning in and looking forward to seeing you next time.